I'm Brittany Lewis with Forbes Breaking News. Senator Bob Menendez urged colleagues on the Senate floor Thursday to support the Anderl Judicial Security and Privacy Act. This bill would add additional safety and privacy measures for federal judges. The House passed legislation this week to increase security protection for Supreme Court justices and their families following the leaked draft decision on Roe v. Wade. Listen in as the New Jersey Democrat describes the act.
Mr. President, I come to the floor once again today to seek unanimous consent for the passage of the Anderl Judicial Security and Privacy Act of 2021. Mr. President, I say once again because a little over a month ago I came to the floor seeking unanimous consent for the same exact bill, which was reported out of the Senate Judiciary Committee last December with overwhelming bipartisan support, and whose namesake is Daniel Anderl, the 20-year-old son of U.S. District Court Judge Esther Salas. Judge Salas is in the gallery today, hoping we can come together as a body to deliver real solutions to honor her family by ensuring that no federal judge or their family experience the same violence that she and her family faced. 1 year, 10 months, and 27 days ago, her son Daniel was brutally murdered by a gunman who targeted Judge Salas for her gender, her ethnicity, and because he could not accept her judgment in a case that reached her court. Every single day since July 19th of 2020, Judge Salas and her husband Mark have endured the immense grief of burying their only son. Mr. President, no parent should have to experience such a devastating loss. Yet in the face of so much pain, Judge Salas has channeled it into purpose, embarking on a personal mission to increase the safety and privacy of her fellow judges and their families. The murderer was able to carry out this horrific hate crime using publicly available information, tracking down Judge Salas to her home in New Jersey, gravely injuring her husband, and murdering Daniel in cold blood when he answered the door. As I said the last time I came to the floor seeking unanimous consent, no parent should have to experience such a devastating loss. But in the months since then and now, our country has seen the tragic results of inaction. On June 4th, a retired county judge in Wisconsin was shot and killed in his home by a gunman who appeared before his court. And just 4 days later, a man was arrested near Justice Kavanaugh's home in Maryland after being found with a gun, a knife, and a plan to kill the Supreme Court justice. Reports suggest the perpetrator found Justice Kavanaugh's address online. We cannot take these events as isolated incidents. The brutal murder of Judge Salas's son, the horrific killing of a retired county judge in Wisconsin, the attempt on Justice Kavanaugh's life demand that Congress act to protect those who sit in the judiciary. Simply put, we must prevent any other judge from having to endure the threats and senseless violence that these families have experienced. After the horrific tragedy Judge Salas and Mark suffered, Senator Booker and I made personal commitments to honor Daniel's legacy through action. We told her we would not rest until we enacted greater protections for those who serve on the bench, to protect any other judge from having to endure the senseless violence Judge Salas experienced. And it's important to protect this branch of our government because we want them to render decisions that are free from fear. Free from fear. That they will render impartial justice free from fear of what may happen to them as a result of their judgment. We can make progress on that work today in this chamber. The bipartisan bill I seek unanimous consent for is an effort I'm proud to lead with 12 of my colleagues, including Senators Booker, Durbin, Graham, Kennedy, Cruz, and Grassley. Our bill would protect the personally identifiable information that assailants have used to target judges and their families. It's a common-sense measure that would authorize the U.S. Marshal Service to monitor online threats and deter future attacks. It's so common sense that it was voted out of the Judiciary Committee with a strong bipartisan support. I'm talking about a 21-0 vote in the affirmative. It's so common sense that it should build on the work the Senate just did a month ago when it fast-tracked important safeguards for Supreme Court justices and their families. I'll say it again. Nearly a month ago, the Senate acted here in mere minutes to increase protections for Supreme Court justices, protections that were proven to be necessary when police apprehended Judge Kavanaugh's would-be assailant. Yesterday, our colleagues in the House of Representatives voted to pass that bill. Today, we should take steps to protect all federal judges. There's simply no explanation or justification to protect Supreme Court justices while delaying legislation to protect judges at every level of the judiciary who face the same, if not greater, risks. No judge in America should have to fear for their lives and the safety of their family as they work to uphold the Constitution, our democracy, and ensure all people have equal justice under the law. We've seen the consequences of inaction over the previous month. But we have an opportunity to act in this moment and advance our bipartisan bill, the Daniel Anderl Judicial Security and Privacy Act, which has continued to garner support. This isn't a partisan issue. This bill is not about right or left. It's about right and wrong. Once again, I ask my Senate colleagues to let us honor the life and memory of Daniel Anderl with decisive action and resolve. Let's do the right thing to honor Daniel's legacy and unanimously pass this legislation named after him. So, Mr. President, as if in legislative session, I ask unanimous consent that the Senate proceed to the immediate consideration of calendar number 190 S2340. Further, that the committee-reported substitute amendment be withdrawn, the Menendez substitute amendment of the desk be considered and agreed to, the bill as amended be considered read a third time and passed, and that the motions to reconsider be considered made and laid upon the table.